a syndicated columnist and editor of Sobran's newsletter. He spoke about the relationship between the Constitution and the conservative movement. His remarks, plus a question and answer session, run nearly an hour.
Thank you very much. Thank you, ladies and gentlemen. I'm honored to be invited to address you today. And thank you, Sam, for an introduction I can't possibly live up to. First, a little plug. I hope you're all familiar with my newsletter, Sobran's, which evaluates the news of the month from a Christian and constitutional point of view. You can get a complimentary copy of the current issue at our display table over here with from Mr. Neff. You can reach us at an 800 number, 1-800-493-3348. And we have a website, www.sobran.com. Very simple. Now, I've had the feeling for a long time that conservatives are groping for something and they're not quite sure what. They disperse their energies on a great many causes. When there's one simple cause they've tended to neglect, and that is the restoration of the U.S. Constitution. Now, the Constitution bears about the same relation to the U.S. government today that the Book of Revelation bears to the Unitarian Church. Or as I like to put it, the U.S. Constitution at present poses no serious threat to our form of government. Look at the push for gun control. That's a no-brainer. The federal gun control is unconstitutional on 4 distinct grounds. First, no power is granted or delegated to the federal government to touch weaponry. Second, just for the liberals among us, the Second Amendment explicitly prohibits it. Now, there's an argument about whether the Second Amendment refers only to state militias because of the opening phrase. But if you read Federalist number 28, Alexander Hamilton, a great advocate of more centralized government, says that the state militias may mount armed resistance to the federal government if it usurps powers. So the Second Amendment, in a sense, was meant to facilitate civil war if necessary. That's not the way liberals construe it. It was to limit federal power, not to minimize the right, as it calls it, to keep and bear arms, the right. The idea, of course, was that the government merely recognized our rights, it did not bestow them. Third, the Ninth Amendment also says that the people retain numerous unspecified rights that are not enumerated in the Constitution. And finally, of course, the 10th Amendment prohibits, it's the pivotal amendment, it prohibits the federal government from exercising any powers that are not listed in the Constitution. Those are reserved to the states and the people. The 10th Amendment is not just a states' rights amendment, as it's often called. It's a limitation on the federal government, as the whole Bill of Rights is supposed to be. So in theory, we the people tell the government what its powers and our rights are. But in fact, the government now determines both its powers and our rights. The result is a living Constitution retailored to suit the liberal agenda. How have conservatives responded to this situation? By and large, they haven't. A lot of them are now distracted by this absurd flag-burning amendment. I drove all the way over from the other side of Fairfax. I didn't see or smell a single flag burning. So we have a conservative movement that gets all agitated about a virtually non-existent problem. And yet, in their zeal to protect the flag, they neglect to defend the Constitution, which has been totally mangled by the liberal regime. In other words, conservatives have been allowing their enemies to write the ground rules, and the revision has been profoundly dishonest, with very little conservative dissent. There are objections to this or that Supreme Court interpretation, but none that goes to the root of the matter. We should notice something else about the reinterpretation of the Constitution by the Supreme Court since, well, even before Franklin Roosevelt, but it got worse when Roosevelt staffed the court with his cronies. The court always discovered that the Constitution supported or even mandated a liberal agenda. They were not, the court was not hewing to the commands of the Constitution, far from it. They were treating it as clay to impose their own will upon. And this is quite clear, in fact, in the obituaries praising the late Justices Blackmun and Brennan. They were celebrated precisely for being, quote, compassionate, etc. That is, for imposing their will on the Constitution. This is what they call a living document. Sounds an awful lot like a dead letter. The living document is, of course, tailored to serve the liberal agenda, basically a socialist agenda, piecemeal. And the Constitution has to be subordinated, as the socialists themselves used to recognize. You can think of the Constitution as a sort of antitrust act for government. Its purpose is to divide power, to make sure there's no concentration of power in the federal government. This is what the debate over ratification was really all about. Recall the Declaration of Independence. It said that these united colonies are, and of right ought to be, free and independent states. Not a new nation, as Lincoln later put it, but free and independent states. And of right ought to be. Notice that. The Articles of Confederation began. Article 1, the style of this confederacy shall be the United States of America. Style meaning name, of course. Article 2, each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not by this confederation expressly delegated to the United States in Congress assembled. Notice the word delegated. Rights, powers were being delegated. They weren't being surrendered, as the court would later put it, using significantly the language of conquest rather than of confederation. The chief anxiety during the ratification debates around the Constitution was whether, given these enumerated powers, the government would become so strong that it could usurp powers never delegated to it. Notice all these words have gone out of use now. We don't talk about usurpation anymore. We don't talk about delegation or enumeration or consolidation. The chief devil word, that meant, of course, centralization. Today, the federal government has become a monolith and the states are reduced to vassals. Nor do the states really object. They're ruled by people who quite willingly accept and exploit the role of dependence on the federal government, which really is no longer federal, but monolithic, centralized, consolidated. Now, the generation that ratified the Constitution agreed that a government that could define its own powers was bound to be tyrannical. And they didn't want the Constitution to permit this. They certainly never intended it. Jefferson warned that if the federal government had the final authority, final and sole authority to interpret the Constitution, it would construe its powers in the broadest way and the people's rights in the narrowest way, and so it has proved. They agreed that God, our Creator, is the source of our rights, and that the people are the source of the government's just powers. Some objected even to adding a Bill of Rights to the Constitution on grounds that it wasn't needed, and their objections were accommodated in the 9th and 10th Amendments. The 9th means that the list of the people's rights in the Constitution isn't meant to be complete, that they still retain many other rights, the right to travel, the right to marry, and so on, which may deserve just as much respect as the rights that are listed. The 10th Amendment, on the other hand, means that the list of powers delegated to the federal government is complete and exhaustive, and that any other powers the federal government assumed would be, in the framers' habitual word, usurped. Our freedom is really safer if we think of the Constitution as a list of powers than as a list of rights. That's the point that's been forgotten in all these debates. We can't list all our rights because they come from God, but we can and do list all the government's powers, which are bestowed by us, the people. By the way, the right of secession wasn't challenged. It was quite consonant with the Declaration of Independence. It was affirmed by the Declaration of Independence. Several states ratified the Constitution with the express condition that they could resume, take back the powers they had delegated at any time. And nobody challenged that. It wouldn't have been practical anyway to prevent a state from seceding at that point. The federal government wasn't strong enough. Now, states' rights are desirable not because the states are always ruled well or benevolently, but because if one state abuses its power, the individual can flee to a less tyrannical one. This relief disappears if all the several states are amalgamated into one huge state, as now. In the same way, private property is desirable because it divides wealth into innumerable small portions of power, preventing one great one. But the federal income tax has subverted this principle by giving the union direct power over every individual. The great principle is divide power. It isn't enough for separation of powers to exist only at the federal level. The original federal plan was to divide power between the states and the federal government, with most of them going to the states. As James Madison says in Federalist 45, the powers of the federal government under the Constitution are few and defined, his words. Those remaining with the states are numerous and indefinite. Today it's the other way around, except the states' powers aren't even defined. He said that the Constitution would not so much add power to the federal government as invigorate its existing powers, and that it would deal mostly with external objects such as foreign affairs, and all the rest would remain with the states. Alexis de Tocqueville, explaining this to his French readers, summed it up well in 2 sentences. The attributes of the federal government were carefully defined in the Constitution, and all that was not included among them was declared to remain to the governments of the individual states. Thus, the government of the states remained the rule, and that of the federal government the exception. Sounds fantastic now, given what we're used to. During the early decades of the United States, the various presidents in their inaugural speeches reaffirmed the principle of federalism, pledging to use the veto to prevent any usurpation of power by Congress. They weren't going to let the states or the Supreme Court decide what a usurpation was and control the interpretation of the Constitution. This principle really came under assault, of course, with the Civil War. Now, the average American, being constitutionally illiterate, has always heard that the war was fought to free the slaves, and of course, you know better. But it's interesting the way Lincoln spun the Constitution. As they say, he declared that the framers had established a new nation. He didn't say anything about free and independent states. He was invoking the Declaration, of course, when he said that the U.S. was dedicated to the proposition that all men are created equal. But he said nothing about governments deriving their just powers from the consent of the governed, nor did he say what happens when they withdraw their consent, a right he had reaffirmed several times as a young man and forgot about. It's interesting that one of Lincoln's recent celebrants, the journalist Gary Wills, said that the Gettysburg, and he meant this as praise, the Gettysburg Address is, quote, a giant, though benign, swindle. Interesting that Lincoln and Roosevelt, the two critical presidents in our constitutional history, both praised their heroes for timely duplicity. It's well known now that it's undeniable that Roosevelt lied to get us into World War II, but of course he's praised for this. So much for democracy and the will of the people. Lincoln wasn't affirming the rights of the slaves, however. He was denying the rights of the insurrectionists, as he defined the seceders. In 1859, speaking in Leavenworth, Kansas, he said, as quoted in the Illinois State Journal, "So if constitutionally we elect a president and therefore you undertake to destroy the Union, it will be our duty to deal with you as old John Brown has been dealt with." A pretty open threat of violence. But to withdraw from the Union is not to destroy it. Those who want to remain can remain. The United States, after all, withdrew from the British Empire, but the British Empire continued to exist. A civil war is a contest for power, but the Confederacy didn't try to take over the U.S. government, only to withdraw from its jurisdiction. The real outcome of the Civil War was to establish that it was government, not our rights, that was unalienable. Unfortunately, the Constitution contains no clear provision for secession. Maybe they thought it didn't have to have one, because it was a natural right of any people to reclaim their independence. In the long run, the war was a Pyrrhic victory for the Union states, which are now as much under federal tyranny as the southern states were. Lincoln and his defenders constantly confused nation with union. Of course, after the war, the North forgot its own claim that there had been no valid secession. It insisted that the rebellious states, so-called, ratify the 14th Amendment as a condition of readmission to the Union. At the same time, they were denying that the states ever had the power to secede or to leave the Union. In fact, they'd already ratified one amendment, the 13th Amendment, abolishing slavery. But the Republicans, born centralizers, didn't perceive their own self-contradiction here. The Union was supposedly indissoluble, yet Congress declared that the Confederate states didn't belong to the Union. That was pretty shameless. And President Andrew Johnson was impeached basically because he held that the Union couldn't readmit the southern states if it held that they had no legal right, or more to the point, no power to secede in the first place. But never mind. The power to enforce the 14th Amendment has been long since usurped by the Supreme Court. although Congress is supposed to enact its provisions by appropriate legislation. And the vaguest phrases in that amendment, which is very ill-written, ill-conceived, permit a limitless mandate for revoking the traditionally reserved powers of the states. Over the next couple of generations, several more amendments were added to the Constitution. Each of them had a clause at the end saying Congress shall have power to enforce this provision by appropriate legislation. The reason for this clause was that everyone understood quite clearly the principle I'm talking about, that the court, the Congress could have no new power unless it was given by constitutional amendment. That's the only way. And so the income tax amendment, the prohibition amendment, and the rest all contain a similar clause saying Congress shall have power to do such and such. Early in the 20th century, the socialists, growing in strength and numbers, realized that the Constitution was a fatal obstacle to their designs. You could not have a monolithic centralized government under the Constitution. It was quite clear that that's what the Constitution was supposed to prevent. Those were the assurances. This is not just original intent. This is right there in the text. There's no other way to read it that makes sense. The federal government has only the powers given to it. The rest are reserved to the people. And as Madison said, why list all its powers if it has a general power to do anything for the, quote, general welfare? James Wilson said, all that is not given is withheld. So there was no doubt about what the Constitution meant, and nobody has made an honest mistake about it since then, except the people who were deluded by the first liars. Then a new strategy emerged on the left, and that was quite a brilliant one. It's been absolutely successful. And that is to reinterpret the Constitution, to make it a living document. This was spearheaded by the revolutionary vanguard of the American Civil Liberties Union, a socialist organization from its inception, whose national board included several leading communists like William J. Foster. How you could work for Stalin and civil liberties at the same time was never really explained. But liberals liked the ACLU's reading. It served the purposes of the court because it made the court a much more powerful institution. Every time the court proclaimed a right or expanded a right, as they say, it was actually usurping a power. Now, contrary to and it only did this to the states. It didn't find the federal government guilty of usurping power. It has very rarely ruled that way. But it constantly found the states violating the Constitution in ways never dreamed of. Its rulings on school prayer and many other issues just shocked Americans because they had never thought of these traditional exercises of state power as even related to the Constitution, except as the reserved powers of the states and the people. So now the court, really felt its oats when Roosevelt, as I say, filled it with its cronies. It virtually repealed the 10th Amendment by declaring it a mere truism, that all which has not been surrendered is retained. And that's where the word surrender appears in constitutional law. Hamilton, of course, said that the Supreme Court would be the least dangerous of the three branches of the federal government. Well, to Roosevelt, it was the chief danger because it kept striking down his socialist fascist programs. And he spoke to the nation on this. In one of his fireside chats, he says, "We have therefore reached the point as a nation where we must take action to save the Constitution from the court and the court from itself." This is when he was proposing to pack the court. But Hamilton also wrote in Federalist number 78 that liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other branches. That union was exactly what Roosevelt engineered. Finally, the court ruled that even growing grain on your own land for your own cows could have a substantial effect on interstate commerce and was therefore subject to congressional legislation. By that standard, everything is interstate commerce. A Kool-Aid stand is interstate commerce if the Kool-Aid or any ingredient in it comes from out of state. They proved far too much. By this reasoning, slavery could have been abolished and prohibition could have been imposed by mere statute, because both of them certainly had a substantial effect on interstate commerce. Later, Rexford Tugwell, one of the brain trust of the New Deal, admitted that their whole program had been based on what he called tortured interpretations of the Constitution. Now, in 1926, Justice William Howard Taft wrote that real effect should be given to all the words the Constitution uses. And again, powers were delegated, not surrendered. And the 10th Amendment, according to the liberal view, doesn't really amend anything. It doesn't have any effect, any real effect. And it apparently doesn't affect the Commerce Clause, which is expanded long after ratification of the 10th Amendment. Why bother amending the Constitution for the purpose of inserting a mere tautology or truism? Was the 10th Amendment supposed to have any effect? Yes. It doesn't do anything in particular except to remind us of the principle that the powers of the federal government are confined to that list. If a proposed bill relies on a power that's not permitted, it's not only not permitted, it's forbidden. This would require the dismantling of most of the powers currently exercised by the federal government, literally thousands of them. The New Deal didn't just expand the power of the federal government. That had been done before. What it really did was to strike at the whole principle of constitutional resistance to federal expansion. You might say that the Civil War put an accelerator on the federal government and the New Deal removed the brakes. This is where the ACLU enters in. It gained its greatest influence after Roosevelt had staffed the court with his men. The New Republic wrote, around the time of the New Deal, to have a socialist society, we must have a new constitution. And the ACLU obliged with a new constitution. Now, since Roosevelt, as I say, very few acts of Congress have been struck down by the Supreme Court on grounds that they go beyond its delegated powers. This bears thinking about because conservatives are always complaining about the court's activism. But vis-a-vis Congress, the court has been quite passive, allowing unlimited expansion of federal power. It's not the Congress's new usurpations of power that the court keeps finding unconstitutional. It's the traditional powers of the states that always turn out to be unconstitutional. And we've gotten so used to it, we hardly object anymore. Once in a while, a real outrage will get us riled up, like the court's 1973 ruling infamously striking down the abortion laws of all 50 states. But in the meantime, we tend to accept the court's rulings as authoritative, even though we may think they're wrong. Well, if they're wrong, they're contributing to tyranny. They're not. Don't forget that Hamilton envisioned judicial review as a way of controlling Congress, checks and balances. He did not envision it as a way of taking away the powers of the states. There was no way to do it. Besides, checks and balances don't apply between a state legislature and a federal court. If the federal court can declare state law unconstitutional, the states are defenseless. Congress is not. Maybe that's why the court has rarely picked on Congress. Well, in effect, this explosion of power has been unopposed, except in a few law journals and in some scattered conservative polemics. In effect, the Supreme Court exercises what you might call a line-item veto over the Constitution. It uses a few elastic clauses, freedom of speech, equal protection of the laws, and so on, to subvert the whole structure and meaning of the Constitution. If you read the Constitution with the liberal interpretation in mind, the whole thing seems like a lot of needless complications. Why is it so wordy? Why does it list these odd powers? Why doesn't it mention the things that the government really does now, chiefly redistributing wealth? So Roe v. Wade was the most spectacular example of the court denying the states a power that had never before been challenged or even questioned. Abortion laws suddenly became retroactively unconstitutional. I'm running a little over here, so I'll skip over this. But Roe v. Wade is the supreme example of not only judicial arrogance, raw judicial power, as Justice White said in dissent, but federal arrogance. It would not have been possible if the states retained the right to secede, because the court would not have dared to suggest anything as absurd as that the states had been acting improperly. All 50 of them had been acting improperly all along by regulating abortion. How could all the states misconstrue the Constitution? How could the Supreme Court suddenly discover that this had always been wrong? Nobody who opposed abortion laws when they were first enacted suggested, as far as I know, that they were in any way unconstitutional. That idea came along in the 60s, in the late 60s. It was simply because abortion was suddenly high on the liberal agenda that the court suddenly found it in the Constitution. And that's how the court has operated. We're dealing here with a problem of amnesia. And I don't mean just among liberals, I mean among conservatives too. We've forgotten our own ancestors. We're out of touch with them. We don't speak or even understand their language very well. And the Constitution, properly understood, would be a great labor-saving device. You wouldn't have to fight about every issue in the way we do now. The National Health Care Plan, for example. You wouldn't have to say, well, it won't work, it'll cost too much, we can't afford it, etc. You'd simply have to say, what an interesting idea. All you have to do is amend the Constitution to give the Congress power to do this, and we'll talk about it. That would put the burden of proof on the socialists and centralizers at all times. Imagine a Supreme Court of a different disposition from the one we've had, just as high-handed as the current court, but with different motives and purposes. Suppose the court wanted to expand not speech rights, but property rights. It might ignore the First Amendment, but expand the clauses in the 3rd, 4th, 5th, 13th, and 14th Amendments, abolishing slavery and the taking of property without compensation. It might hold that these clauses created penumbras formed by emanations, such that the graduated income tax, the welfare state, and most federal regulation of business were unconstitutional. Well, that's a daydream, but you can see how the shoe could be put on the other foot. I'm not advocating it. I'd like to see the Constitution honored on all sides. And I'd like to see conservatives emulate the ACLU. It's a brilliant strategy, took a long time, but it really worked. The long march through the Constitution. The ACLU has changed the understanding of the Constitution of nearly all educated, or at least semi-educated people. It shouldn't be impossible for conservatives to do the same for the Constitution, to deny that it's a living document. When I was in school studying Shakespeare and Chaucer and Milton, it was always the task of scholarship to understand what their words meant in their own time. You were never free to impose your own interpretations on those words on grounds that they were living documents. That's not how it works. And the Constitution is not written in an archaic language, though we're making it archaic by neglect. These words, usurpation, delegation, enumeration, consolidation, are still in the dictionary. We can still use them, and that's what we really ought to be doing, instead of getting excited about flag burnings. Has there been a flag burning since 1968 in this country? I know there are a lot of foreign flag burnings. Maybe we should attack them too. Anyways, Sam says it's time for questions, and I thank you very much for your attention.
I was ordered to give you that. Thanks very much, Joe. How much time do we have for questions? 15 minutes. We have to be out of this room precisely at 12 o'clock. We have to go into lunch at that time. So please keep your questions very brief, and please do not make speeches yourself, and I hope that Joe will not make speeches in responding to your questions. However, if Joe wants to make speeches, he may do so. Jared Taylor has the first question.
I'm curious to know your view as to why the states, since the Civil War, seem to have so cheerfully given up what powers they still maintained at the end of that war. Why have governors not been willing to retain the powers the Constitution so clearly grants them?
Well, yeah, revenue sharing, somebody said. That's the Republicans' idea of federalism. The Republicans had quite a monopoly of power after the Civil War. By the way, the inaugural addresses I referred to by the first few presidents, and Grover Cleveland later, affirming the principle of federalism, ceased with James Buchanan. Lincoln said no such thing. He made no promise to uphold the Constitution. You know the old joke, by the way, about Barry Goldwater? Conservatives were envisioning his inauguration in 1964, and they imagined President-elect Goldwater standing before Chief Justice Earl Warren, and Warren saying, "Do you swear to uphold the Constitution of the United States?" And Goldwater said, "I do. You're under arrest, Warren." But, you know, some of the states surrendered passively. Some put up resistance, of course, but usually on very narrow grounds. And a lot were bought off by this booming federal government. You know, Roosevelt boasted that, quote, "no damn politician will ever be able to undo my Social Security system." It was unconstitutional, but it's almost impossible to dislodge because so many people are on the take now. Sam?
To a certain extent, that states' rights, like absolute right of kings or feudalism or whatever, is a concept that time has left behind. And I would say that primarily, my question to you is, due to mass immigration and mass mobility in America, there are very few of us that in America now that were born in states where our families live. Many of my friends have lived in 5 or 6 states in their lives, and doesn't this preclude the kind of loyalty to your state that existed when the 13 colonies seceded and for some decades thereafter?
Yes, I think that's true, that the mobility and migration problems do weaken attachments to the individual states. But that's why I say we should not think of the 10th Amendment chiefly as a states' rights amendment, as it's often miscalled. It's a limitation on the federal government. It's a dividing power amendment. That's the important thing. Always to divide power. That's what the framers constantly stressed, and what the anti-federalists were chiefly concerned to sustain as a principle.
Leonard Wilson has a question. Leonard?
Do you, Mr. Sobran, see a glimmer of hope in a few of the recent Supreme Court decisions relating to states' rights?
Well, I didn't follow this last round closely. I haven't caught up with them yet. There may be a glimmer. There was a glimmer in the Lopez case when the court insisted that the federal government had no power to ban firearms within a certain distance of public schools. So there are people, Justice Thomas for one, who are aware that the 10th Amendment is there. I once met Justice Scalia on a rainy December day when Washington was just, the traffic was absolutely clogged, and everybody at the place where we met was complaining about it. And I pointed out that this would never have happened if we'd adhered to the 10th Amendment. Because, of course, the streets and roads were built to sustain a limited government. And as government usurped powers, it overwhelmed the street system. So we're paying for it. I hope those who commute will at least be impressed by this argument.
Frank Foreman.
What do you think will happen in, say, 30 years from now as opposed to what we'd like to happen? What changes do you see taking place besides increasing awareness of what a rotten deal we have? What changes do you see in the structure of business and various social changes do you have? What do you think will happen in, say, 30 years?
Well, I usually refrain from predictions because I get so many predictions wrong, and so does everyone else who makes predictions. Luckily for journalists, people don't really keep score. But I don't know. I think it depends on us. We have to exercise our free will. The future is fluid, always is. But I am encouraged by what Bill Clinton laments as our cynicism about government. I wonder if he's ever stopped to think why people might be cynical.
Gentleman, yes, sir.
Quick question. Have you read the book Hologram of Liberty by Ross, and do you like it, or have you heard of it?
What?
Hologram of Liberty. Book.
No, I don't know that book.
It just takes the Federalist Papers, the Anti-Federalist Papers, and shows the history from the Articles of Confederation and who did what and why to transfer over to the Constitution.
You know, the interesting thing about the ratification debate is what both sides agreed on. They all agreed in principle, at least in public, that the consolidation of power in government was bad. How sincere Hamilton was may be open to question, but at least he adopted the posture that it was bad for the sake of persuading his audience.
We have one more question. Yes, 15 Page.
Joe, I agree. I didn't see any flag burnings coming over here either, but there have been a few over the last several years, mainly by communists and troublemakers. But my question to you is really this. If it's outrageous for the Supreme Court to strike down the abortion laws of all our states, can't you argue that it's equally outrageous for the Supreme Court to strike down dozens of state laws protecting the national symbol? And isn't the desire for a flag amendment to protect the national symbol from desecration a legitimate response on behalf of a national symbol, not by conservatives really, but by mostly the American Legion and millions of veterans in this country. And shouldn't that kind of movement be encouraged?
Well, Cliff, thanks for asking, because I meant to make something clearer than I did. The court's decision that flag burning is an exercise of First Amendment rights was judicial outrage, one more usurpation of power. That power belongs to the states, but I don't think it's practical or a wise use of our energies to try to amend the Constitution, which is a great labor, every time a Supreme Court decision usurps power. I mean, I'm trying to think of a way to amend the Constitution to require that the Constitution be observed. That's what we really need. And that's why the ACLU strategy has worked so well. But I think people are ready to be re-educated now. In fact, the rise of homeschooling and increase of private schooling gives me considerable hope, too. It doesn't take that many people. The ACLU is not 88% of the population. It's a subversive cell, a cancerous cell in the body. And a few determined people could, with equal determination, correct that gross and unsustainable misunderstanding.
Okay, we're out of time. Thank you very much.
Thank you. Thanks very much. Great to see you.
There's an announcement.
Excuse me, we're going to be breaking for lunch now. Please remember to write your names on the back of your ticket for a drawing later on. And please remember to be here at 1:15 for our next panel. The lunch will be out in the lobby, and please have your tickets ready. Thank you.
You haven't seen his house.
Tomorrow at noon on C-SPAN, an Attorneys General Forum from Atlanta.